the United States Senate delivered a thunderous constitutional blow to Donald Trump's presidential ambitions this morning when 71 senators voted to pass the Presidential Accountability and Disqualification Enforcement Act, sweeping bipartisan legislation that codifies procedures for enforcing Section 3 of the 14th Amendment and establishes a federal framework allowing courts to determine whether individuals have engaged in insurrection and are therefore constitutionally disqualified from holding federal office. The historic 71-29 vote represents the most significant congressional action on presidential accountability since Watergate, with 21 Republican senators joining all 50 Democrats, create veto-proof supermajority support for legislation that Trump has denounced as unconstitutional persecution designed to eliminate him from the presidential race through legislative action rather than allowing voters to decide his fate at the ballot box. And this isn't some symbolic resolution or non-binding expression of congressional concern that carries moral weight but lacks enforceable legal consequences. And this is Congress exercising what the legislation sponsors argue is explicit constitutional authority granted under Section 5 of the 14th Amendment to create enforcement mechanisms for Section 3's disqualification provisions, establishing federal court jurisdiction over eligibility challenges, setting evidentiary standards and procedural rules for adjudicating whether individuals have engaged in insurrection, and creating penalties for state officials who place constitutionally disqualified candidates on ballots in violation of judicial determinations. When the United States Senate passes legislation by a 71-29 supermajority that establishes federal judicial procedures for determining whether presidential candidates engaged in insurrection and creates mechanisms for removing them from ballots based on court findings. And when that legislation attracts support from 21 Republican senators, including senior committee chairs and former Trump cabinet officials, the legal and political implications cascade through every level of American government and create unprecedented framework for judicial resolution of Trump's eligibility that could definitively end his presidential campaign through court proceedings rather than through electoral defeat. Hit that subscribe button right now because you won't want to miss any of the videos I release. So what specific provisions does this legislation contain and how does it purport to affect Trump's eligibility for the presidency? And according to the 247-page bill that President Biden is expected to sign into law within 72 hours, the Presidential Accountability and Disqualification Enforcement Act establishes several key mechanisms for enforcing Section 3 of the 14th Amendment. First, the legislation grants original jurisdiction to federal district courts to hear challenges to the eligibility of presidential candidates based on allegations that they have engaged in insurrection or rebellion against the United States or have given aid or comfort to enemies thereof. The jurisdictional grant allows any registered voter to file suit in federal district court challenging a candidate's eligibility, with cases to be heard by 3 judge panels and subject to direct appeal to the Supreme Court, bypassing the normal appellate court process to ensure rapid resolution before elections occur. Second, the legislation establishes evidentiary standards and procedures for Section 3 cases, providing that plaintiffs must prove by clear and convincing evidence that defendants engaged in insurrection as defined by the statute, that defendants are entitled to full due process protections, including discovery, witness examination, and presentation of defenses. And that final judicial determinations of ineligibility are binding on all state and federal officials responsible for administering elections. Third, the legislation creates enforcement mechanisms, including criminal penalties for state election officials who knowingly place disqualified candidates on ballots after courts have determined their ineligibility, civil penalties allowing voters to sue officials who violate the law, and federal court authority to issue injunctions ordering removal of ineligible candidates from ballots. This isn't Congress simply expressing disapproval of Trump's conduct or making aspirational statements about the importance of constitutional accountability. This is Congress creating detailed legal framework with jurisdictional grants, procedural rules, evidentiary standards, and enforcement mechanisms designed to ensure that Section 3 disqualification can be adjudicated and enforced through federal courts, with Supreme Court review ensuring constitutional issues are resolved definitively before elections occur. And believe me, when Congress passes legislation by veto-proof supermajority that creates federal court procedures specifically designed to adjudicate whether presidential candidates engaged in insurrection, and when that legislation is clearly drafted with one specific candidate in mind, even if it purports to apply generally to all candidates, the intended target understands that the institutional machinery of government is being mobilized to end his political career through legal mechanisms rather than through the uncertain processes of electoral competition. Here's the full picture of what's been unfolding through intense congressional negotiations and constitutional deliberations over the past 5 months. Discussion of federal legislation to enforce Section 3 gained momentum after the Supreme Court's March 2025 decision in the Colorado ballot case, where the court ruled that states lack authority to enforce Section 3 absent congressional implementation legislation. That decision created a legal vacuum where Section 3's disqualification provisions existed in constitutional text but lacked enforceable mechanisms because Congress had never passed implementing legislation and states could not act unilaterally. But the legislative effort accelerated dramatically in September 2025, when a bipartisan working group led by Senators Mitt Romney, Susan Collins, and Chris Coons began drafting comprehensive enforcement legislation after consulting with constitutional scholars, former federal judges, and election law experts. The working group conducted extensive hearings throughout October and November 2025, receiving testimony from dozens of witnesses addressing questions about Congress's enforcement authority under Section 5, about appropriate standards of proof, 4 Section 3 cases about procedural protections necessary to ensure due process for accused individuals, and about enforcement mechanisms that would ensure judicial determinations are respected by state officials. The hearings generated a comprehensive legislative record demonstrating that Section 5 explicitly grants Congress power to enforce 14th Amendment provisions through appropriate legislation. That's creating federal court jurisdiction and procedural frameworks constitutes appropriate enforcement legislation, and that the Supreme Court's opinion in the Colorado case effectively invited Congress to enact such legislation by identifying the absence of federal enforcement mechanisms as the reason states could not act unilaterally. The draft legislation was released in December 2025 and immediately generated intense controversy. Trump's legal team and Republican congressional leadership initially argued that the legislation was unconstitutional, that it represented a bill of attainder targeting Trump specifically, and that creating special judicial procedures for eligibility determinations violated equal protection and due process principles. However, the legislation's sponsors made strategic modifications addressing some concerns, including broadening the statute to apply to all federal offices rather than just the presidency, creating robust procedural protections for defendants, including discovery rights, an ability to present witnesses, and establishing clear and convincing evidence as the standard of proof rather than the lower preponderance standard initially proposed. These modifications reduced opposition and convinced moderate Republicans that the legislation served legitimate constitutional purposes rather than representing partisan targeting of Trump. Smash that like button if this is making sense so far. Here's where it really gets serious. When the Senate Judiciary Committee conducted markup sessions on the legislation in January 2026, Republican opponents launched a filibuster attempt that required 60 votes to overcome the initial cloture vote on January 28th, succeeded by a 64-36 margin, with 14 Republican senators joining all 50 Democrats to end debate and move to final passage. But during the week between cloture and final passage, additional Republican senators announced they would support the legislation after reviewing the Supreme Court's Colorado decision and concluding that Congress has both authority and responsibility to create enforcement mechanisms, constitutional provisions that lack self-executing enforcement. Senator Lindsey Graham, who had initially opposed the legislation, delivered a dramatic floor speech on February 3rd, announcing he would vote for. And final passage, despite concerns about the bill's implications for Trump, Graham argued that the Supreme Court had clearly indicated Congress should act, that Section 5 grants enforcement authority, and that failing to create enforcement mechanisms would leave Section 3 as dead letter, unable to fulfill its constitutional purpose of preventing those who engage in insurrection from holding office. Graham's announcement provided political cover for other Republicans considering supporting the bill, and the final vote count of 71-29 exceeded even the legislation's sponsors' expectations. And let's be honest for a moment. When 21 Republican senators vote for legislation creating federal court procedures for determining whether presidential candidates engaged in insurrection, knowing that those procedures will almost certainly be used against the leading Republican candidate for president, it signals that substantial portions of the Republican caucus have concluded Trump represents such a threat to constitutional governance and to the party's long-term viability that they are willing to support mechanisms that could eliminate him from the race, even at the cost of enraging Trump's base supporters and potentially ending their own political careers through primary challenges. Here's what multiple congressional and legal sources say about the legislation's key provisions and how they will operate in practice. The jurisdictional grant provides that any registered voter may file suit in the United States District Court for the District of Columbia or in the District Court for the district where the challenged candidate resides, seeking a declaration that the candidate has engaged in insurrection and is therefore disqualified under Section 3. Cases must be assigned to special 3-judge panels consisting of 1 circuit court judge and 2 district court judges selected randomly from a pool of judges serving in the relevant circuit. The 3-judge panel requirement is designed to ensure that no single judge can determine a presidential candidate's eligibility and to provide immediate appellate-level review within the initial proceeding. Cases proceed on an expedited schedule with discovery limited to 60 days, motions practice limited to 30 days, and trial to the court, not jury, to be completed within 90 days of filing. The evidentiary provisions define engagement in insurrection as participating in or providing material support to violent or forceful resistance to the lawful authority of the United States government with intent to prevent, hinder, or delay the execution of federal law or constitutional processes. The definition explicitly includes inciting, organizing, or directing others to engage in such violent or forceful resistance. Plaintiffs must prove by clear and convincing evidence that the defendant engaged in insurrection as defined, that the defendant had previously taken an oath to support the Constitution, which all former presidents have done, and that no congressional amnesty has removed the disqualification. Defendants may present evidence demonstrating they did not engage in insurrection, that their conduct was protected by the First Amendment, or that other constitutional defenses apply. The legislation specifies that criminal conviction is not required for civil disqualification under Section 3, explicitly rejecting arguments that only criminally convicted insurrectionists can be disqualified. The enforcement provisions require state election officials to remove from ballots any candidates whom federal courts have determined are disqualified under Section 3, with removal required within 48 hours of receiving notice of a final judicial determination, and state officials who knowingly violate this requirement face criminal penalties, including up to 5 years imprisonment and civil penalties of up to $100,000 per violation. The legislation authorizes expedited civil actions by voters seeking injunctions ordering compliance with prevailing plaintiffs entitled to attorney's fees. Federal courts are granted authority to issue injunctions directly ordering state officials to remove disqualified candidates from ballots, backed by contempt sanctions for non-compliance. Drop a comment right now if you saw this coming. I read every single one. Now things get absolutely critical for understanding how this legislation will be used against Trump and what timeline will govern those proceedings. Multiple groups of voters have already announced they will file Section 3 challenges against Trump under the new legislation within days of it becoming law. These groups include Free Speech for People, a constitutional advocacy organization that previously filed Section 3 challenges in state courts, Citizens for Responsibility and Ethics in Washington, CREW, which has been involved in Trump-related litigation for years, and several groups of individual voters from swing states who will serve as named plaintiffs. The lawsuits will be filed in multiple jurisdictions, including the District of Columbia and districts where Trump maintains residences, creating parallel proceedings that will likely be consolidated for efficiency. The complaints will cite extensive evidence compiled through the January 6th committee's investigation, through federal criminal proceedings, through the Senate's findings in its Section 3 resolution, and through various court proceedings where judges have made factual findings about Trump's conduct. The evidentiary record that plaintiffs will present includes testimony from dozens of witnesses who observed Trump's actions. During the period between the 2020 election and January 6, documentary evidence including emails, text messages, and recorded phone calls showing Trump's awareness that fraud claims lacked foundation and his intent to prevent the peaceful transfer of power. And expert testimony from constitutional scholars and historians regarding whether Trump's conduct constitutes engagement in insurrection under the statute's definition. Legal experts who have reviewed draft complaints expect that plaintiffs will present cases capable of meeting the clear and convincing evidence standard, particularly given the volume of evidence now available through various investigations and proceedings. That's when it became clear this legislation represents not merely a theoretical framework for future enforcement of Section 3, but rather a carefully designed mechanism for immediately challenging Trump's eligibility, with strong likelihood of judicial determinations that he is constitutionally disqualified. The bombshell aspect of the legislation's design is the expedited timeline that ensures cases will be resolved before primary elections occur by requiring discovery to be completed in 60 days. Motions to be resolved in 30 days and trials to occur within 90 days of filing. The legislation contemplates that Section 3 cases filed in February 2026 could produce final 3-judge panel decisions by May or June 2026. Direct appeals to the Supreme Court would occur under equally expedited schedules, with the legislation requiring the court to grant certiorari and to hear cases on the merits within 60 days of notices of appeal being filed. This timeline means that Supreme Court decisions could be issued by late summer 2026 before general election ballots are finalized and potentially even before the Republican National Convention selects its nominee. This legislative action sent immediate and profound shockwaves through American politics, the legal profession, and Trump's presidential campaign. When Congress passes veto-proof legislation creating federal judicial procedures specifically designed to adjudicate whether a leading presidential candidate engaged in insurrection, it fundamentally transforms the political landscape from one where Trump's eligibility was a matter of political debate and state-by-state litigation into one where federal courts will make definitive, binding determinations that either allow Trump to remain on all ballots or require his removal from all ballots nationwide. The uncertainty that has characterized the eligibility question will be replaced by judicial finality one way or another within months. This isn't the first time Congress has passed legislation implementing constitutional provisions or creating enforcement mechanisms, but the Presidential Accountability and Disqualification Enforcement Act represents an extraordinary exercise of legislative power with clear partisan implications despite bipartisan support. Think back to the Voting Rights Act of 1965, where Congress exercised its enforcement authority under the 15th Amendment to create detailed procedures for federal oversight of state voting practices and for Department of Justice pre-clearance of voting changes in jurisdictions with histories of discrimination. The Supreme Court upheld that legislation as appropriate enforcement of constitutional protections, establishing precedent that Congress has broad authority to create enforcement mechanisms for constitutional provisions, even when doing so constrains state authority and creates federal oversight of traditionally state functions. Then there was the Americans with Disabilities Act of 1990, where Congress exercised enforcement authority under Section 5 of the 14th Amendment to create comprehensive anti-discrimination protections and enforcement mechanisms, including private rights of action and detailed procedural frameworks. The Supreme Court initially questioned some aspects of the ADA's application, but ultimately upheld the legislation as appropriate enforcement of equal protection principles, demonstrating judicial willingness to defer to congressional judgments about what enforcement mechanisms are appropriate for constitutional protections. Subscribe immediately if you haven't yet. This content doesn't exist anywhere else. And let's not forget the various civil rights enforcement statutes passed during Reconstruction, many of which created federal court jurisdiction over constitutional violations and established criminal penalties for state officials who violated constitutional rights. Those statutes were upheld as valid exercises of congressional enforcement authority despite arguments that they improperly federalized areas of law traditionally left to states and despite their clear targeting of specific regions and political factions that had engaged in insurrection or its aftermath. Now, however, the context is even more politically charged because the legislation, while written in general terms applying to all candidates, is transparently designed to be applied against one specific individual who remains the leading candidate of one major political party. The pattern across American history shows that Congress has broad enforcement authority that courts typically uphold. But the Presidential Accountability and Disqualification Enforcement Act tests the limits of that authority by creating enforcement mechanisms clearly intended to affect ongoing political competition through judicial removal of candidates from ballots. So what constitutional principles and historical precedents support Congress's claimed authority to pass this enforcement legislation? According to the legislation's extensive findings section and the congressional record compiled through months of hearings, Section 5 of the 14th Amendment explicitly grants Congress power to enforce by appropriate legislation all provisions of the amendment, including Section 3's disqualification provisions. The Supreme Court has repeatedly recognized that Congress has broad discretion to determine what constitutes appropriate enforcement legislation, with judicial review limited to whether legislation is rationally related to enforcing constitutional provisions and whether it respects principles of federalism and individual rights. The legislation's sponsors argue that creating federal court jurisdiction, establishing procedural frameworks, and requiring state compliance with federal court orders all constitute rational means of enforcing Section 3 and do not violate federalism because the 14th Amendment itself constrains state authority and because the Supreme Court's Colorado decision established that federal action is necessary for Section 3 enforcement. Here's the kicker. The legislation includes a 3-page appendix containing historical documents from Reconstruction demonstrating that the framers of the 14th Amendment specifically contemplated that Congress would pass enforcement legislation for Section 3 and that such legislation would include federal court jurisdiction and mechanisms for removing disqualified individuals from ballots. The appendix quotes extensively from congressional debates in 1866, 1867, and 1868, where members discuss how Section 3 would be enforced, with multiple statements from the amendment's principal drafters explaining that enforcement would occur through federal court proceedings authorized by congressional legislation. The appendix also includes examples of Reconstruction-era enforcement legislation that created federal court jurisdiction over Section 3 cases and established procedures similar to those in the current bill, arguing that modern legislation follows historical precedents established during the only previous period when Section 3 was actively enforced. Don't go anywhere. The most explosive part is coming next. And here's what should alarm Trump about the practical implications of this legislation, regardless of arguments about its constitutionality. Even if Trump's attorneys ultimately convince the Supreme Court that the legislation exceeds Congress's enforcement authority or violates constitutional constraints, that litigation would occur only after federal district courts conduct expedited trials examining extensive evidence of Trump's conduct and potentially making factual findings that Trump engaged in insurrection. Such factual findings, even if later set aside on grounds that courts lack jurisdiction to make them, would be politically devastating and would provide Trump's opponents with judicial determinations about his conduct that could be used in campaign advertising and political messaging. The legislation creates a scenario where Trump faces the worst of both possible outcomes. Either federal courts determine he is disqualified and remove him from ballots, or federal courts make factual findings that he engaged in insurrection, but then have those findings vacated on jurisdictional or constitutional grounds, leaving Trump politically damaged even though legally he remains on ballots. This puts Trump in an extraordinarily difficult legal and political position heading into the critical months of primary season. On one side, he faces imminent Section 3 lawsuits under the new federal legislation, requiring him to defend in federal court against allegations that he engaged in insurrection, with plaintiffs presenting extensive evidence compiled through multiple investigations and proceedings. Trump must simultaneously prepare for his federal criminal trial on election interference charges while defending Section 3 cases that cover overlapping factual territory, creating enormous demands on his legal resources and requiring coordination between criminal defense and civil litigation strategies that can sometimes conflict. On the other side, he faces the reality that federal courts will make factual determinations about whether his conduct constituted insurrection, with those determinations either resulting in his removal from ballots or providing his political opponents with judicial findings, and they can weaponize even if he ultimately remains on ballots. And here's the tricky part that makes this legislation so potentially case-ending for Trump's presidential campaign. The expedited timeline means that Supreme Court resolution could occur before the Republican National Convention in July 2026. If the Supreme Court affirms 3-judge panel determinations that Trump engaged in insurrection and is disqualified, the Republican Party would face the unprecedented situation of its leading candidate being ruled constitutionally ineligible. Just weeks before the convention, the party would need to coalesce around an alternative nominee with minimal time for that candidate to build national campaign infrastructure or to unify a party deeply divided between Trump supporters and those who supported the disqualification. And conversely, if the Supreme Court reverses disqualification determinations, Trump would claim vindication, but would still bear the political burden of judicial proceedings that examined evidence of his conduct and that at minimum included lower court findings against him, even if ultimately reversed. Legal and political analysts are calling this legislation the most consequential congressional action affecting a presidential election since the post-Civil War Reconstruction amendments themselves, creating unprecedented framework for judicial adjudication of candidate eligibility with direct and immediate implications for ongoing electoral competition. Lawrence Tribe, the Harvard constitutional law professor who has studied Section 3 extensively and who testified before Congress in support of the legislation, told news outlets that the Presidential Accountability and Disqualification Enforcement Act represents Congress fulfilling its constitutional responsibility to create enforcement mechanisms for provisions that would otherwise be dead letters. Tribe explained that Section 3 without enforcement legislation would be like having constitutional protections without remedies, and that the Supreme Court's Colorado decision essentially required Congress to act if Section 3 was to have any operative effect. Do me a favor and slam that like button because it genuinely helps this video reach more people. Even some conservative constitutional scholars who generally oppose expanded congressional power have acknowledged that the legislation rests on the plausible constitutional foundations, and that Section 5 enforcement authority likely permits the kind of framework Congress has created. Michael McConnell, the former federal appellate judge and Stanford law professor known for his conservative jurisprudence, stated in interviews that while he has concerns about whether the legislation is wise policy, he believes Congress likely has constitutional authority under Section 5 to create federal court jurisdiction and procedural frameworks for Section 3 enforcement. McConnell emphasized that the Supreme Court will likely uphold the legislation's basic framework while potentially modifying specific provisions that might raise constitutional concerns, meaning that Section 3 litigation will proceed under some version of the federal statutory scheme, regardless of challenges to particular aspects of the legislation. So let's break down precisely what this legislation means for Trump's campaign, for the Republican Party, for the integrity of the electoral process, and for fundamental questions about the relationship between constitutional law and democratic choice. First, the immediate impact is that Trump will face Section 3 lawsuits in federal court under expedited procedures that require resolution within months. Plaintiffs will present extensive evidence from the January 6th committee, from federal criminal proceedings, and from Senate investigations, and from various court proceedings where judges have made factual findings about Trump's conduct. 3-judge panels will evaluate that evidence under the clear and convincing standard and will make determinations about whether Trump engaged in insurrection as defined by the statute. Those determinations will be subject to direct Supreme Court review, with final resolution likely occurring before the general election and possibly before the Republican National Convention. Second, the litigation will generate intensive media coverage and public attention as evidence is presented in open court proceedings that will be live-streamed and extensively reported. Witnesses will testify about Trump's actions and intentions. During the period between the election and January 6th, documentary evidence will be introduced showing Trump's knowledge and conduct, and expert witnesses will address whether Trump's actions constitute insurrection under constitutional standards. The public will receive more comprehensive presentation of evidence than occurred during impeachment proceedings or through media coverage of investigations, because formal court proceedings require structured presentation of evidence. Subject to cross-examination and judicial evaluation, the political impact of evidence presentation could be substantial, regardless of ultimate judicial determinations about Trump's eligibility. Third, Republican Party leadership will face agonizing decisions about how to proceed if courts determine Trump is disqualified. Party rules and traditions assume that primary voters select nominees and that those nominees are legally eligible to serve if elected. A judicial determination that Trump is constitutionally disqualified would force the party to either replace him with an alternative nominee or to resist the judicial determination by supporting Trump's appeals and arguing that courts lack authority to disqualify candidates. The first option would enrage Trump supporters and could fracture the party, while the second option would place the party in the position of rejecting federal court authority and constitutional disqualification provisions, potentially alienating moderate voters and creating constitutional crisis. Drop a comment below with your thoughts. I'm genuinely curious to see your perspective. But beyond the immediate implications for the 2026 election, this legislation establishes framework that will govern Section 3 enforcement for all future elections and all future candidates who might face disqualification. The precedent created will influence how political competition intersects with constitutional eligibility requirements, how courts balance enforcement of constitutional provisions against democratic principles favoring voter choice, and how Congress exercises enforcement authority under constitutional provisions that grant broad legislative discretion. The long-term implications may prove even more significant than the immediate application to Trump. Because the legislation creates permanent machinery for judicial adjudication of insurrection allegations that could be invoked against candidates from either party in future elections. This scenario is generating intense debate across the political spectrum about the appropriate balance between enforcing constitutional disqualification provisions and allowing voters to choose their leaders. Trump supporters view the legislation as the ultimate example of establishment politicians using procedural mechanisms to overturn democratic choice, arguing that voters, rather than courts, should determine whether Trump's conduct disqualifies him from office through the electoral process. They contend that Section 3 is being weaponized to eliminate a candidate that tens of millions of Americans want to support, and that judicial disqualification based on subjective assessments of whether conduct constitutes insurrection represents dangerous precedent that could be abused to eliminate political opponents in future elections. Trump opponents counter that constitutional disqualification provisions exist precisely to prevent voters from electing individuals who have engaged in insurrection. That treating Section 3 as enforceable only through voter choice would render it meaningless, and that enforcing constitutional provisions through judicial proceedings represents rule of law rather than undermining democracy. They argue that just as voters cannot elect someone who fails to meet age or citizenship requirements, they cannot elect someone who is disqualified under Section 3, and the courts have both authority and obligation to enforce constitutional eligibility requirements, even when doing so overrides voter preferences. Meanwhile, Trump responded to the legislation's passage with extended statements and a press conference denouncing it as the most unconstitutional law ever passed by Congress and as a coup attempt by establishment politicians who fear his return to power. Trump characterized the legislation as a bill of attainder specifically targeting him as exceeding Congress's enforcement authority by creating judicial proceedings that violate his due process rights, and as fundamentally undermining democratic governance by allowing courts and Congress to override voter choice. Trump announced that his legal team would immediately challenge the legislation's constitutionality in federal court and would seek preliminary injunctions preventing any Section 3 cases from proceeding under the statute until constitutional questions are resolved. He predicted that the Supreme Court would strike down the legislation as exceeding congressional authority and violating separation of powers. The press conference featured Trump flanked by Republican members of Congress who opposed the legislation and by constitutional lawyers who will challenge its validity. Trump delivered an extended denunciation of the 21 Republican senators who voted for the bill, calling them traitors who betrayed their party and their voters, and promising that those seeking re-election would face primary challenges from Trump-endorsed candidates. Trump characterized the legislation as proof that the entire political establishment, including Republican leadership, has conspired against him, and argued that his supporters must recognize the election as a battle between ordinary Americans and corrupt politicians who will use any mechanism, including unconstitutional legislation, to maintain their power. Stay with me. What comes next will completely change how you view this situation. Here's what makes this entire situation so unprecedented and potentially explosive from constitutional, legal, and political perspectives. The legislation creates the possibility that federal courts could determine Trump is constitutionally disqualified from the presidency while tens of millions of voters want to elect him, forcing a direct confrontation between constitutional law and democratic will. If courts determine Trump engaged in insurrection and order his removal from ballots, Trump supporters will view this as judicial coup, overriding legitimate electoral competition. If courts determine Trump did not engage in insurrection, or if constitutional challenges to the legislation succeed, Trump opponents will argue that dangerous precedent has been set, allowing those who attempt to overturn elections to return to power without meaningful accountability. Either outcome will leave substantial portions of the electorate viewing the process as illegitimate and will create long-term damage to public confidence in democratic and legal institutions. Moreover, the legislation's expedited timeline creates scenarios where judicial proceedings and electoral competition operate on parallel tracks, with each influencing the other in ways that could distort both processes. Federal court proceedings examining evidence of Trump's conduct will occur while primary voters are casting ballots, potentially influencing voter decisions before judicial determinations are final. Court rulings on Trump's eligibility could occur after some states have held primaries but before others, creating situations where Trump wins delegates in states that voted before disqualification but is removed from ballots in states voting after judicial determinations. The intersection of legal and political timelines creates chaos and uncertainty that the American electoral system is poorly equipped to handle. Legal experts immediately identified multiple constitutional challenges Trump's attorneys will raise against the legislation, including arguments that it constitutes a bill of attainder by targeting a named individual through legislation, rather than through general laws of applicability, that it exceeds Congress's enforcement authority under Section 5 by creating substantive rights rather than merely providing remedies for constitutional violations, that it violates due process by creating inadequate procedural protections and biased adjudicatory frameworks, and that it violates separation of powers by allowing Congress and courts to override electoral choices made by voters. Each of these arguments has some legal foundation, and courts have never addressed most of them in the specific context of Section 3, enforcement legislation, making outcomes genuinely uncertain despite the legislation's strong vote totals and bipartisan support. This goes far beyond affecting Trump's individual political fate or the outcome of the 2026 election. It establishes precedent about congressional power to enforce constitutional provisions through legislation, creating federal court jurisdiction and procedural frameworks, about judicial authority to disqualify candidates from ballots based on constitutional eligibility requirements, and about the relationship between constitutional law and democratic processes when the two conflict. The legislation and the litigation it generates will influence American constitutional law and political practice for generations, regardless of how courts ultimately resolve immediate questions about Trump's eligibility. If this blows your mind, hit that like button right now. Here's the situation in the starkest possible terms. Congress has passed by veto-proof supermajority legislation creating federal court procedures for adjudicating whether presidential candidates engaged in insurrection and are constitutionally disqualified under Section 321. Republican senators joined all Democrats to support the legislation, despite knowing it would be used against their party's leading candidate. The legislation establishes expedited procedures, ensuring cases will be resolved before the election. Multiple lawsuits will be filed against Trump within days and challenging his eligibility under the new statutory framework. Federal courts will examine extensive evidence and will make determinations that either remove Trump from all ballots nationwide or allow him to remain on ballots while bearing political damage from judicial proceedings. The Supreme Court will review those determinations on an expedited basis, with final resolution likely before the Republican National Convention, and the nation faces the prospect of constitutional disqualification provisions being enforced against a major party candidate for the first time in 150 years. When Congress creates federal judicial machinery specifically designed to adjudicate whether a leading presidential candidate engaged in insurrection, with procedures calibrated to ensure resolution before the election, and with bipartisan support demonstrating that substantial portions of both parties view the candidate as potentially disqualified. It represents extraordinary exercise of legislative authority that tests fundamental assumptions about the relationship between constitutional law and electoral democracy. The legislation transforms what had been political debate and fragmented state-level litigation into unified federal judicial process that will produce definitive binding determinations that either end Trump's candidacy or clear him to remain on ballots. Keep a close eye on this rapidly developing situation as Section 3 lawsuits are filed, as Trump challenges the legislation's constitutionality, and as federal courts begin evaluating evidence and making preliminary determinations about expedited proceedings. The legal and political battles will intensify dramatically in coming weeks as the full machinery created by the legislation begins operating. Media coverage will shift from political horse race coverage to intensive focus on legal proceedings that could definitively resolve Trump's candidacy one way or another, and the American public will grapple with profound questions about whether constitutional disqualification provisions should override voter preferences and whether judicial determinations about insurrection represent rule of law or represent judicial overreach into political competition. Before we go any further, smash that subscribe button so you never miss the content like this. Here's precisely where things stand right now in unambiguous terms. Federal legislation creating Section 3 enforcement procedures has passed with veto-proof majority. Trump faces imminent lawsuits under the new statutory framework. Federal courts will make binding determinations about his eligibility within months. A Supreme Court will review those determinations before the election. Republican senators have supported legislation likely to be used to disqualify their party's leading candidate. Constitutional crisis looms as judicial proceedings intersect with electoral competition, and fundamental questions about the relationship between constitutional law and democratic choice face resolution through proceedings with no historical precedents. This isn't just another chapter in Trump's legal troubles or another political controversy that will fade from headlines. This represents Congress exercising constitutional enforcement authority in ways that could definitively end Trump's presidential campaign through judicial removal from ballots and creating precedent that will influence how constitutional eligibility requirements interact with electoral politics for generations. What happens in federal courts over coming months will determine not only Trump's political fate, but will establish whether Section 3 operates as enforceable constraint on candidates or whether it remains dead letter, unable to prevent those who engage in insurrection from seeking power. The legislation is passed, the lawsuits are coming, the courts will decide, and the test of whether American constitutional system can enforce disqualification provisions against popular candidates faces its most significant examination since Reconstruction. The stakes have never been higher. The constitutional questions have never been more consequential. And the shock move by Senate has sent ripples across Washington that will transform American politics and law in ways still unfolding. Pause for a second and hit that like button if you're finding value in this comprehensive coverage.